Good afternoon, sir. Good afternoon, Dame Sandra and Dr. Steward. We were in the middle of case study 2. We had dealt with 2 issues, and we were turning to the 3rd issue that you had identified. Can we turn up in the second report, please, page 70? Here you express your conclusions on the 3rd issue, which is the roles of the Chief Executive Officer and her executive colleagues. And between paragraphs 262 and 271, you set out your conclusions on this issue. And you make the point that how a CEO leads his or her team is not an exact science. And do you mean that within the governance code and other similar instruments, there is a reasonable body of divergence in how you discharge the obligations?
I believe that the principles are set at such a high level that how that one fulfills those principles, I don't mean a high level in terms of height of standard, I mean in terms of generality, at such a level of generality that it is possible to be an effective chief executive and adopt different styles.
You go on to explain, and remembering this is in connection with the treatment and administration and response to the second site report.
Yeah.
You say you would have expected the chief executive, that's Paula Venables, to be well aware of all issues which were covered in the report, insofar as they significantly impact Post Office. By that, do you mean you would have been expected to her to have been well aware of issues before receipt of the report or upon receipt of the report?
That we would expect her to be aware of the issues of which she was aware before receiving the report, but upon receiving the report, we would have expected her to be aware of those issues that were within the report.
Okay, so she should have been across the detail of the report upon receipt?
Across the particular aspects which we pick out in the report, which we see to have been significant.
You say you expect, you would have expected her to be leading her executive team so that she would have been well aware of the significant views and actions of each of her executive directors, so she could bring all significant, relevant information into her decisions. Can you assist us what you're referring to there?
I'm referring to the fact that as chief executive, she naturally delegates and expects her different executive directors, her members of her top team, to be more in touch with details of their particular areas than she is. But nonetheless, we would expect that the way in which she operated that team, that if there were significant areas identified within individual executive directors' areas, that they would be brought to her attention.
You say that in dealing with the report in paragraph 264, she and some of her executive colleagues appear to be disproportionately focused on communications and public relations, and that whilst messaging and communication are vital parts of executive responsibility, the executive responsibilities in matters covered by the report extend to many areas, including, or especially, technology, business operations, prosecutions, and the law. What led you to the conclusion that she and some of her colleagues appeared to be disproportionately focused on public relations and communications?
Because from the evidence that we saw, there was a great deal of communication about how the positioning of the publication of Second Sight interim report should be put, how communication should go to James Arbuthnot and other MPs, and what the media statement would say. Looking beneath what Second Sight interim report said, where, as we shall see, they identified a number of issues to do with Horizon, to do with prosecutions, to do with the impact of current processes on sub-postmasters, that they didn't seem so concerned with those things.
Do you accept that a board owes a fiduciary obligation to protect a company's reputation?
Do I accept that the board has that responsibility?
Yeah,
yes.
fiduciary. Do you accept that a general counsel has a fiduciary obligation to protect a company's reputation?
Well, a general counsel has many different roles. Would you like me to expand upon that? The general counsel has a role as her independent advisor to the board, to bring her expertise to the board and to the company on a legal basis. If the general counsel is a director of the company, then she or he also has duties as a director, which, as we covered earlier, relate to directors' duties. If that's the second role she may have, although in relation to the Post Office, the General Counsel didn't have that role. If she also has functional responsibilities for areas of work, for example, the legal area of work or the risk area of work or aspects of the operations area of work, for example, security, she also has duties in relation to her functional leadership. This means that she can be both a member of the executive team and an independent advisor. And general counsels are often put in the position of holding those dual roles.
If it is the case that members of the board, and they say this, received assurances from within the business that Horizon was a robust system and that any and all allegations about it were unfounded, would it be appropriate or inappropriate for a board to respond to those allegations in a way that sought to protect the company's reputation?
One would expect the board to inquire into any matters which suggested that the assurances that they had been given were not as foolproof as they had been led to believe. And if we look at the particular instance of the Second Sight interim report, whilst there was the general conclusion of no systemic problems so far discovered, there was the discovery of bugs, anomalies, whatever one wishes to call. And therefore that might have been a basis for saying, well, given that we've been told on the one hand it's robust, and yet given on the other hand we've been told that there are bugs and defects, should we not think about what is the connection between those two pieces of information? And should we not then inquire further into what it means that this is robust?
Thank you. At 265, you say you hadn't seen evidence that the CEO, Paula Venables, ensured broad collective executive discussions about the findings of the report, which included contributions from or challenges to all functions and aspects of the business. Can you explain what you mean by what you were looking for in the evidence there?
We were looking for something more than what are the top-level messages we can give. Namely, the top-level messages were Horizon is robust, there's no systemic problems with it. There are a number of things we've got to do with regard to training and support, and we'll do them. But what was really understood about the nature of the technology? What was really understood about the meaning of bugs and defects? What was really understood about the experiences of sub-postmasters as related in the Second Sight interim report? we were looking for a broader sense of contribution from the executive team into the meaning behind the Second Sight interim report.
You say in the fifth line, it's as if specialist functions are each in different black boxes which non-experts cannot assess and do not feature as part of their shared executive responsibility. And you cross-reference to some sections of Ms. Vennell's oral evidence where she says she's not an expert in this or an expert in that. And then over the page to page 266, sorry, paragraph 266, you say that she appears to have left the preparation of the Horizon Update paper to the General Counsel, Susan Crichton. The inquiry heard that Ms. Crichton discussed a draft with the company secretary, made amendments, for example, to refer to defects rather than bugs. And you don't know if the CEO and General Counsel discussed the contents of the paper. That we heard that the CEO felt uncomfortable and ill-equipped when she was suddenly required to present the paper at the board meeting, which to you suggested an executive team which is fragmented, where a sense of shared collective responsibility for all aspects of the business is faint, a mindset which has grown within an organisation where functional silos, certainly in IT and legal, extend from the top to the bottom. Can you expand in any way on the conclusions which you drew there?
I think we then have to look at the role of the chief executive. The chief executive cannot be an expert in all matters of running the business. That's very, very well understood, which is why the chief executive needs to delegate to a number of her executive team's specialist responsibility. But that very action of delegation does not absolve the chief executive from seeking to understand the whole picture. So whilst there is delegation, there is also inclusion of bringing these matters up into the chief executive's mind so that she is sufficiently aware of all the aspects which impact the consideration of any particular issue. So that's the chief executive role. The chief executive's role is also to ensure that her executive directors to which she delegates, imagine them all in their little functional boxes, that they not only communicate upwards and downwards to her, but she ensures that they communicate across each other and that they bring to bear areas of their specialist expertise to their collective understanding. And that's what we did not see evidence of. Of course, we're very happy to look at evidence which suggests something different to that, but we did not see any evidence of that. And we understand that that sense of both delegation and yet bringing together, that sense of individual responsibility and yet collective responsibility, was something which we did not see in relation to consideration of the interim report of Second Sight.
And I think it's right that you have not examined and do not opine on the motives for that approach.
We do not.
In paragraph 268, in the second line, you say, in your view, the Chief Executive Officer, Paula Vennells, did not ensure that the board, before the meeting, that's the meeting of the 16th of July, was fully briefed on important matters, particularly those relating to post office policy and practice on prosecutions. It was reasonable that she should flag her immediate concerns about communications, but they were concerning how the story was being told, not about the nature of the story itself. Is there anything you wish to expand upon?
I believe that's quite clear, unless there were further questions you'd like to ask.
No, thank you. You developed that theme in 269 by saying communications to the non-executives in between the 1st and the 16th of July were focusing on PR rather than substance. Is that right?
That is correct.
And then over the page...
And perhaps I should just add that's relevant to that. There's this memo, 3-page memo that went with the circulation of the Second Sight interim report. It was a very detailed analysis of where the executive felt there were factual inaccuracies. which didn't really affect the substance of the report, and it meant that the concentration was on those factual inaccuracies, not the substance of the report.
Would it be fair? No, I think that's probably a bridge too far. Can we go over the page, please, to 269? Sorry, to 270. You say it would have been more appropriate to accompany notification to the non-executives of publication of the report with an executive summary of the key points, rather than to do what the memo did, which was to focus on inaccuracies. And that did nothing to dent the important messages which could be discerned from the report.
Exactly. That was the point I anticipated when I spoke earlier.
Thank you. Is there anything else you want to say in relation to this sub-issue?
Well, we'll probably come on to it, but the lack of an executive summary of the key points, either from the second sight interim report or in the board update paper, meant that the job of the board in interrogating that paper was made to an extent more difficult.
Thank you. Can we turn to issue 4, the role of the chair, which we can see starts at the bottom of that page, and go to your conclusions on page 75, please. You make a similar point, as you did in relation to the CEO, as regards the chair in paragraph 284. And you make, I think, a similar point in paragraph 285 as you had in relation to the CEO. Is that right?
That's exactly right.
You say you would have expected the chair, that's Alice Perkins, to have interrogated the report to see for herself if there were any issues or problems flagged in the findings beyond those identified by the CEO. We would have expected her to give careful consideration to how she wished the board to engage with all the findings of the report, the purpose and expected outcome of the board discussion. Why would you have those expectations of the chair?
Because I believe, and we believe, based on the role of the chair in governance, that her responsibility is to ensure that any paper or any matter which is brought to the board, that she understands what the issues and problems are which it is being suggested.
Over the page to para 287, is this essentially your view on, or your counterpoint, setting out what should have happened in the board meeting itself as opposed to what did happen?
Yes, indeed. And I perhaps should say that in relation to each of these case studies, we are using the base of report number 1, as we described. If we feel there is need for additional background information, then we've provided it in the introduction to the cases. Here, where we talk about the chair at administrative level to agree how the paper is to be presented and so on, we felt perhaps we hadn't put enough information in report number 1, so we added it here.
Okay. And so here you're saying there needed to be agreement or direction as to who was going to present this important paper. Is that right?
Exactly.
Whether they were to be invited into the meeting and involved in both presentation and discussion, and then carry those directions into effect.
That's correct.
Is that right?
That's correct.
What did you, what view, if any, did you form of the evidence as to what in fact happened at the 16th of July?
I believe we come to that later,
Okay.
which we can take now or we can take later.
Can you discuss it now in the context of this expectation?
Well, the expectation, as we'll see, was, as we understood, that the General Counsel would be present and would present the report. That did not happen.
You say in 288 that you would have expected Alice Perkins to make it a priority that Susan Crichton was present at the meeting and that Alice Perkins had been fully briefed by Susan Crichton, despite the apparent strains in their relationship. Why is it that you pick this topic, the Horizon report by Second Sight, for such treatment?
Why did we choose Second Sight?
Yes. On the occasion of the board meeting, there were
Yes.
a number of papers before the board,
Yes.
not just this one.
No, but our case study is about the handling of the Second Sight interim report,
Yes,
and therefore that is what we addressed.
yes. I'm asking you indirectly, and I'll make it more direct. Would you expect this kind of liaison and prior agreement to occur in relation to all papers tabled before a board?
I would expect the chair to be fully aware of the agenda that she has either proposed or agreed with the company secretary, and to know how that agenda was going to unfold, who was going to present what, who was going to prepare what. She herself, as the chair, would have views on that, and it would be ultimately her decision, but she would probably discuss these with the chief executive and the company secretary. So the idea that the chair has responsibility for the agenda is absolutely the case, whatever the item which is there before the board.
And so you're not picking out the Second Sight report here for special treatment?
No, no.
Okay, got
If
it.
that's the question, the answer is no.
Got it. You say that you found no evidence that Alice Perkins prepared in this way, and that once in the board that she chaired the meeting in such a way as to ensure that the full import of the findings of the report were appreciated and discussed, with decisions on follow-up actions agreed.
And we'll come to that in more detail, I believe, in subsequent issues.
Yes, can we turn to sub-issue 5 then? That's set out what the issue is on page 76, the role of the NEDs, and your conclusions are expressed in paragraphs 302 to 304 on pages 79 and 80. If we can turn to those, please. 302, just scroll down, thank you. You say, given the amount of external interest in Horizon, its role in prosecution of sub-postmasters, and the fact that Second Sight would be reporting on alleged problems with the Horizon system, you would have expected the CEO to keep the NEDs sufficiently apprised at a high summary level of emerging issues from the work. Minutes of the board meeting on the 23rd of January 13 record the chair rather than the CEO giving a brief update on work being undertaken by Second Sight, including, quote, to date there was no evidence to suggest fault. Had the NEDs had a hint of any major issues, they may have been alerted to questions they may wish to raise. No such information until the board call on the 1st of July was received. And so, are you speaking essentially about priming the NEDs here in the run-up to the delivery of the Second Sight report?
Yeah. I'm talking about the fact that when you're a non-executive director and there is a matter going on for over a year, and the board had specifically asked for some updates, probably after January, that if there was anything emerging, of course there may not have been anything emerging, but if there was anything emerging, we'd expect a brief update so that the NEDs are aware, a hint of any major issues. They'll be alerted to questions they may wish to raise. If what they're told, which may have been all there was to tell, I don't know, if they're told to date there is no evidence to suggest fault, that is an indication that we can relax, all things going well.
I think you point to a second aspect in which the NEDs were not properly briefed in paragraph 303, and this focuses on the board call on the 1st of July 2013. Yeah. You say the limited time for the call, the fact that the report wasn't listed as an agenda item or flagged in advance by email, there was no briefing paper that related to it before the call, created circumstances in which the NEDs could not begin to exercise their role in scrutiny or challenge.
Yeah.
Essentially, are you saying here that this was just an item that was dropped in?
It was entirely dropped in. The board call was called about strategy, we believe, or we're led to believe, it opened with the chief executive saying, "Oh, we're expecting the interim report to be published on the 8th of July. And that they would get a copy of it then. But they didn't know this was what was going to be the subject of the call. They got no briefing paper. So it was, in a way, the first they'd heard of the publication.
You say, I think, drawing those threads together in 304, the non-executive directors were, in your view, inadequately briefed. This was exactly the time when they were expected to exert their independence, and that the circumstances prevented them from doing so.
Yeah.
Is that right?
I believe that to be the case. And the reason why you might say, well, how is it that it would be exactly the time they should exert their independence if they knew nothing of it? But they knew nothing of it from within the post office. But they were, however, aware of the large-scale media influence and the influence and the interest of MPs into the matters that Second Sight were inquiring into. So one might have thought they'd be alert to say, well, let's try and understand this a bit better. But they couldn't do that on the basis of the 1st of July call because they didn't know that they were going to hear about it.
Thank you. Turning to sub-issue 6 within this case study, it set out there what could the board have taken from the contents of the report published on the 8th of July. You set your conclusions out on page 82. On to 83, paragraphs 310 to 312. And you say the report contained much information which should have attracted the attention of the NEDs, warranted serious discussion by the board, because it raised issues about post office investigations and prosecutions policy and practice, the attitudes of the post office, the sub-postmasters, the impact of their contracts, and contested evidence about the robustness of Horizon. Much of the information does not feature in the conclusions or in some easily accessible summary form in the Second Sight report. Are you there pointing out that you have to read the report carefully and slowly in order to extract the important issues that you have there identified?
I am. It's not handed on a plate. It's hardly handled in any way, but within the report, very important matters are raised.
And not handed on a plate in terms of a good executive summary.
Exactly.
You say in 311 that it would have been good practice for Post Office to require Second Sight to write such a summary, and for the Post Office to have written their own executive summary for the board. And that in the absence of both of those things, it was even more important that the non-executives interrogated the report for themselves. You say the messages identified above are evident. By that you mean obvious when one reads the document?
A careful read, particularly against the background that we have described, would have meant that these matters were obvious in our view.
And likely to be seen by as highly significant to a careful reader. But without executive signposts, they needed to be drawn out from a reading of the report and fully interrogated, and that's what the NED should have done.
Yeah.
Can we turn, please, to the board meeting itself on the 16th of July, and this is where you deal with issues 7, 8 and 9. Issue 7 you identify as what were the contents of the board paper, that's for the purposes of the meeting on the 16th of July, prepared, and how was the board paper received by the board?
Yes.
and your conclusions are set out in paragraph 323, which starts on page 86. You refer us back to the first time that the fact that the board had seen anything of substance or heard anything of substance was the board call on the 1st of July when they were given a brief and partial introduction to the report. When they got the second site report, it wasn't accompanied or followed by a note from either Paula Venables or Susan Crichton summarising the major issues. The report isn't identified as a subject for board discussion on the 16th of July. Do you mean that in the board papers?
I mean, yes, the paper is called Update Following On, or I can't remember the exact word, but it's an update subsequent to the second site interim report. So the second site interim report is never as such laid before the board meeting. It has been made available to the board on the 8th of July when it is published, and then this is an update consequent upon that. In a way, it's implied as a presence in the board, but it is not expressly put in the board papers.
And so you're identifying the absence of a note which says, for example, discussion of the contents of the
yes,
report of the 8th of July.
Yeah, or a summary of the contents.
You say the update paper covers some but not all the issues identified in the report, but does so in a structure which makes some of them somewhat opaque. What were you referring to there, if you can recall?
What I was referring to was the fact that, as I've indicated, the second site interim report had lots of bits of information which were highly germane to the issue of the post office's prosecutions and investigations, attitudes to sub-postmasters, the use of Horizon data in prosecutions, and the robustness of Horizon. They were peppered around, and that, as I've said before, wasn't, as it were, handed on a plate. And that then, the update report deals with what's happened after the publication. And that update report addresses a number of matters which are, I hope, in this section identified, but which the fact that there wasn't an executive summary meant that the significance of some of the point had to be extracted by the reader rather than, again, being given on a plate of an executive summary.
And again, in your examination of the issues, I don't think you attribute motive or intention
we do
to
not.
The relevant actors here, i.e. why this was done.
Didn't hear.
You don't attribute motive or intention to the relevant actors.
We don't.
Why this was done in this way.
We don't. We note that that was what was happened.
And that it is a departure from the reasonably expected standards that you set out in Report 1.
And also if we look at paragraph 325, we had a checklist of normal expectations of a board. Now this is, you won't find this in the code of conduct on the code of governance. This is more drawing upon our own experience and also the experience that you can find in many board evaluation processes, where one of the subjects for discussion is usually about how are your board papers presented, do you have any areas where you think there should be improved, what's the normal standard you expect. So this summary is our summary based on our experience, on the experience of other experts in board governance, and in thinking about the way in which one can run effective boards.
And in summary, you find that out of the 8 items on the nominal checklist, 4 were non-existent, 2 were partially existent, and 2 were in existence.
Indeed.
If we go over the page, please, to 327. and 8, you say that Paula Venel should have ensured a comprehensive summary of the major issues was explicitly and comprehensively drawn to the board's attention. However, there was nonetheless sufficient information in the report and the update paper to alert and engage Ned that the board should fully interrogate the issues and require the CEO urgently to report back on whether there were major risks in the 3 things that you mentioned. And that wasn't done according to the evidence that you have seen.
That's correct.
Is there anything else you want to speak to or identify in relation to this sub-issue 7?
Well, we're dealing with an expectation that Ned should be informed of major issues. And we're dealing with an expectation that the chief executive will gather together all the information that she has to bring to the attention of the board. Little bits of that process may not happen, and they may not happen in many boards, but when you have the confluence of those various aspects coming together, particularly given that this is known, we're now in 2013, this is known to be to address a number of very serious issues for the post office, then we would expect there to have been more attention paid to the areas that we've identified.
Thank you. Can we turn to issue 8, the quality of the discussion and the quality of the decisions made at the board meeting on the 16th of July? Issue 8. Now, you set out a series of conclusions here. They begin at page 92. And within this sub-theme, you identify, if we scroll down to paragraph 346, some themes or conclusions. And there are 6 of them. I'm not going to ask you to speak to each of those 6 points that arise from the discussion at and the decision-making of the board on the 16th of July, but instead turn to your overarching conclusions about them. That's page 100, paragraph 375 and following. So in the light of the 6 sub-points that you've examined, you say, in your view, the board's receipt and discussion of the update paper was a missed opportunity for the board. Notwithstanding their annoyance with the management of the process, the board knew that the post office's present unresolved situation with sub-postmasters and its defence of the Horizon system was consuming large amounts of time and energy in the business and threatening that which the board held dear, namely the public reputation of the post office. It knew that the accounts, of the accounts of human hardship and suffering from sub-postmasters, which were current in the press and media and of great concern amongst some MPs. So you were saying, notwithstanding the manner in which the issue and the materials were presented to the board, there was a failure by the board.
To look above their annoyance, to look above the irritations, the lack of immediate evidence, the lack of evidence on a plate, to look in above and also then to go into the detail. That is what we would have expected.
In paragraph 377, you say that the executive did not help the board to see the bigger picture or take a longer time perspective, but the boards could itself still have focused, required more focused, coordinated and sustained work, which is likely to have revealed the magnitude and interconnectedness of the risks in front of them. And then over to 378, if the NEDs have made such challenges, it would not have crossed the line between business and board and meant that the NEDs were necessarily not supportive of the executive. NED challenge to executive is a fundamental part of their role. Can you explain what you meant by that paragraph, please?
Yes, well, it's often said in governance terms that NED shouldn't interfere with the running of the business. It goes back to the earlier point we had this morning about the board not involving itself in operational matters, which are matters for the executive to run. However, if the board believes there is evidence to suggest that those operations are not proceeding within the reasonable bounds of expected performance, or if they believe there are other questions or matters that they should consider, then they should inquire of the executive, well, what really is going on here? And that doesn't mean that they would be overstepping and interfering. Rather, it means that they would be exercising their due responsibility in relation to the matters.
Thank you. Can we turn to the last issue in this case study, number 9, which is the behaviour by relevant actors, in fact, before the board, i.e. in a pre-meet, and in the board itself. And your conclusions start at paragraph 389 on page 103. And you're addressing two things there, the pre-meeting of the NEDs and then the exclusion of Susan Crichton from the board meeting itself. And you say it's relevant to ask if such a series of events is unusual in the conduct of board affairs. How did you answer that question?
We answered the question to say non-executive directors getting very exercised and angry about something that is in their board papers is not totally unusual in pre-meets. In pre-meets of non-executive directors, there's often expressions of unhappiness in relation to certain things that are being done. So a NED pre-meet which is exercised by what they see to be failings of the executive is not totally unusual. I think in both our experiences we've come across them. And indeed, it's often said that one of the reasons for a NED pre-meet is that they can get together and share their experiences without totally voicing them in the board. So annoyed non-executives meeting before a board meeting is not totally unusual. Excluding people who expected to be at a board meeting is also not totally unusual. I mean, sometimes because of pressure of time, sometimes because at the pre-meet, people have decided that the board paper isn't yet ready to be considered. People may be stood down. Perhaps we'll go on to the manner of standing down in a minute. But so excluding executive members from a board meeting is again not outside our experience. The General Counsel, one could argue, is in a special case because as we addressed her responsibilities earlier, she has both responsibilities as an executive director and she has responsibilities as the General Counsel. And I have never personally come across, nor have I ever seen it written about, where a General Counsel was expected to be before a board and was then subsequently excluded. So the exclusion of executive directors because there's not time or because their paper isn't ready is not that unusual. Excluding a General Counsel is pretty unusual, and I've never come across it.
Can I ask, unusually, Dr. Steward, whether you have?
I have never come across it, no.
Thank you. What view did you form of the reasons given, or what the reactions ought to have been for the reasons given for excluding the General Counsel on this occasion, i.e. that there were concerns over how she had managed the project?
The question to me is?
Did you form a view as to the reasons given for excluding Susan Crichton from the board?
It appeared to be, and this is our reading of the evidence we've seen, it appeared to be that the non-executives were so exercised with their irritation about how the second site work and the conclusions in the interim report had been raised. They were so annoyed about that they were expressing a lot of criticism of the General Counsel. And that appears to have insofar as she speaks about this, have caused the chair to think, well, the best thing is that we have this discussion in the board without the presence of the General Counsel. We go on to consider other matters, I think, later.
Page 105, paragraph 396. Is that you is essentially setting out your proposed solution if the facts are as described by the chair?
Indeed.
I.e., there were two issues. One said to be about the General Counsel's performance in relation to the project, but nonetheless there was a remaining issue as to the substance of the report. The substance needs a discussion. She's the person who knows most about it.
Exactly.
You draw, I think, a wider conclusion in paragraph 397 that takes us outside the case study. Mm-hmm. Can you explain that, please?
Well, I think it arises from our analysis of the case study. The board had no senior lawyer, either as a member of the board or as a routine attendee. Perhaps I should say in context for generally accepted standards, and I should also say that the role of the General Counsel in boards has developed over time, and I'm mindful of the fact that we're dealing here with 2013, not with 2024. Nonetheless, as it happens, I can remember facilitating a discussion of General Counsels around this time about their role in the board. And I can say that in general, and these may be larger businesses rather than smaller businesses, in general, a board would have had a General Counsel who was either, probably not a member of the board, but who was a routine attendee. But in this case, they had no one who was a regular attendee. Susan Crichton only came in if she was specifically required. That, in our view, is probably in 2013, most General Counsels would have been regularly in attendance, probably, but not all. But she was the most important senior lawyer in the organisation. There were important legal matters on the agenda, not simply this update, but also there was this significant litigation report for noting. So what was happening by her not being at that board was that the board was denied its own legal specialist, who appeared to be the only person who understood the legal matters raised by claims for wrongful prosecution, because as we've seen earlier, the chief executive who ended up presenting this report herself asserted on many occasions, or several occasions, that she herself was not a lawyer and didn't altogether understand these matters.
Can we go over the page, please, to paragraphs 399 and 400? You draw a third point from this episode, and you mention the impersonal, public, and some might say humiliating treatment of Susan Crichton, which implies a disrespect for colleagues and a lack of human sympathy. You say that in 400, this appears to give you strong signals about the culture of the boardroom. You can be sure that even as this was happening, rumours, speculation, etc. would have been rife within HQ. It suggests a disrespect for colleagues, a board which doesn't care about people, a rift between the General Counsel, the chair and the board, and a silence in the face of consideration for others. How serious a state of affairs are you describing there?
I'm describing there something which both reflects and then becomes instantiated within the culture of the boardroom and has wider ramifications for the culture of the organisation. Cultures are made up of stories, of accounts of things that happen. Sometimes they're mythical, sometimes they're substantive. And I think that this, leaving a General Counsel, a very senior member of the executive team, sitting outside a boardroom, which she is expecting to go into, is a significant matter, and it would have been a subject for great, I imagine, discussion and speculation within the organisation. I don't know if you want to add anything to that.
Only the general point, I think, which is that cultures are exactly that. They morph and they change. That cultures are made up of what you see going on around you and what you experience. And if you see going on around you people being excluded from meetings, then the culture becomes one in which it is easier to accept that this is the way we do things around here.
Thank you. Can we turn to case study 3, please? That begins on page 109 and concerns case study 3, the handling of Simon Clarke's advice by the executive in 2013. You set out this case study over a large number of pages, over 30 pages, from page 109 onwards. Again, there's a crisp summary of the facts from paragraph 412. You say, Susan Crichton received legal advice from Cartwright King, Post Office's prosecuting solicitors, because preliminary conclusions from the second sight report were showing that there were bugs in the system which impacted branches. Mr. Clarke realised this finding might call into question the integrity of some prosecutions and might have resulted in some miscarriages of justice, and volunteered the advice. Ms. Crichton understood from Mr. Clarke that some sort of review of cases may be needed to establish the size of the problem and to enable some sort of disclosure to defendants if there was a risk their convictions were unsafe. Susan Crichton met Cartwright King and received a summary oral report of what would become known as the Simon Clarke advice on the 3rd of July. You say you've assumed that the oral summary would have been explicit about the serious problems of Fujitsu's Gareth Jenkins as a witness, which are at the centre of the Simon Clarke advice. This was 5 days before the publication of the interim report on the 8th of July 2013. Although the written advice was received by the Post Office legal team on the 17th of July, it was sufficiently clear from the face-to-face meeting on the 3rd of July that immediate action was needed. A review of cases and requirements for disclosure, which became known as the SIF review, was instituted on Ms. Crichton's instructions to be conducted by Cartwright King. When the General Counsel received the written advice on the 17th of July, she shared it with members of the legal team, Hugh Flemington and Roderick Williams. She doesn't remember reading it herself, she says in her witness statement. By this time, actions on the SIFT review are well underway. And then over the page to 416, the Clarke advice outlines the duties of an expert witness. It shows how the evidence relied on by the expert witness, Mr. Jenkins, was tainted. It concludes that Post Office will need to conduct a disclosure exercise for sub-postmasters where convictions have been secured on the basis of horizon evidence, and that those grounds for appeal will be able to go to the Court of Appeal. It says emphatically that the existing witness, Mr. Jenkins, cannot be used again. You then set out over the following pages, I think, 6 issues, the first of which is who should have received the advice. That appears between paragraphs 4, your conclusions on that appear between paragraphs 438 and 448, and they start on page 116. You say if it's found that neither Susan Crichton from July to November 13 nor her successor Chris Oyard until 2015 informed the board of the Clarke advice, specifically that criminal prosecutions may have been undermined by the failure of Gareth Jenkins to disclose bugs in the system, then this is a failure of governance, in so much as governance is a combination of formal roles, competence, and formal and informal relationships. It's not a failure which can be laid simply on those two general counsel, the General Counsel must be able to speak their mind, represent their professional responsibilities in the sure confidence they'll be listened to. What were you implying there, if anything?
One could say simply that the General Counsels did not give explicitly the information contained in the Simon Clarke event in all its elements. They did give bits of the evidence, even as early as the board update paper written by Susan Crichton, where she said that they had a legal duty to review some prosecutions, which is informed by the Simon Clarke advice. But even if they didn't let it all out, as appears to us, then whether or not someone speaks, whether or not someone presents information, is a matter of how they think both it will be received and what they believe other people to know. And so in that sense, we would say that it's not simply on them that they didn't speak it in total. They gave out bits of it, and perhaps we have no idea, but it's possible that they just thought they should get on with doing the bits that they could do. Namely, in Susan Crichton's way, she had immediately started the SIFT review, which was a direct response to the Simon Clarke. Do you want to add?
Yes, I think there are a number of different routes to board for the Simon Clarke advice. There was the Susan Crichton talking to the chief executive. The chief executive said she didn't understand it and didn't communicate it to the chair. Susan Crichton could have escalated it to the chair. There is the opportunity that was missed, if you like, when Susan Crichton was in the boardroom on the 16th of July for her to communicate face-to-face the contents of the Simon Clarke advice. So this 439, what we're trying to pull out is that actually the communication of this advice, getting into the boardroom, needed a collective effort. It is about the relationships, it's about the social processes, which mean that the information gets to the place where it needs to be got to.
I think there's also an indication there's an email, I think, from Alwyn Lyons to Paula Venables, relating the fact that she's spoken to Susan Crichton shortly after Susan Crichton's exclusion from the board, in which Susan Crichton says she would have talked about the criminal cases had she been in there. Whether or not she would have included specifically the Simon Clarke advice, we do not know.
Can we look, please, at paragraphs 447 and 448 on the next page? You refer back to some of the evidence given by Paula Venables to the effect that this is a legal matter, this is an issue for legal, implying a failure to integrate legal knowledge into collective executive discussions and decisions. And if it's the case that legal knowledge is in a black box, which the CEO and others do not need to or cannot understand, you say this implies that legal is almost semi-detached from the business, and Paula Venables is happy for issues of a legal nature to remain the responsibility wholly of the General Counsel and legal advisors. Can you explain, please, how this relates to the distribution of the Clarke advice?
The distribution of the Clarke advice. I think that if you have what I imagine happening in most circumstances would be that a chief executive would say to her general counsel, we have got the second sight report, we have evidence of bugs and defects in the system, what are we doing to understand the implications of that for us? And that the general counsel would have legal knowledge, but it wouldn't just sit with the general counsel. It would sit within the general counsel and the chief executive in communication, because this is a significant risk to the business, and the chief executive is ultimately pivotal in terms of taking that risk to the board. So it's not something which sits just within a legal silo. And I think that's what we're trying to pull out here, is the extent to which it sat within a legal silo, or it was seen as a collective appreciation of the risk to the business.
Thank you. So that's a convenient moment for the afternoon break. Can we break until 3 o'clock, please, before we turn to issue 2? Thank you, sir. Dame Sandra, Dr. Steward, we were in the middle of case study 3, looking at the end of issue 1 and moving to issue 2. Can we turn up page 117, please, of the second report? You're dealing with the question from this paragraph onwards, what should have been done with the Simon Clark advice of July 2013? Can we look at your conclusions on that issue, please? Page 128. Paragraph 483 at the foot of the page. You say, when looking at what should have been done with the advice, we make the following observations. On receipt, the Post Office executive, led by the General Counsel, needed to take immediate action to review past and present criminal cases and start the disclosure exercise using the process agreed with Post Office's lawyers, Cartwright King. Susan Crichton recognised that immediate action was needed and acted on the advice of the lawyers so that the SIFT review was underway by the time of the 16th of July board meeting. It was a broad executive, not just a legal responsibility to review the conclusions of the Simon Clark advice and make recommendations. Initially discussed and agreed with the EXCO to the board. All functional heads share responsibility for briefing the CEO and their team colleagues, but the CEO's role in focusing the team on issues for the business is crucial. The prosecution policies would almost certainly have been thought a priority by EXCO had they considered it. It should have been addressed as a matter of great urgency. Any member of EXCO who are board directors have an ultimate duty to the board to bring any matters of consequence to the board. The General Counsel should have been in regular contact with the CEO throughout the week before the board meeting, conveying to the CEO the lawyer's proposals and initial work, and they should have been jointly discussing any implications for the business and assessing risk. The General Counsel generally has a duty to fully inform the Audit and Risk Committee and the board, and in order to protect the business in situations where the CEO may not be doing this. The General Counsel has a direct duty to the board. If they felt at any time when the board was making important decisions of policy, the board was being given incomplete or inaccurate information, whilst obviously in a difficult situation, they must inform the chair of their concerns and express their opinion at the Audit and Risk Committee, even when it differs with that of the CEO. They should discuss or continue to discuss differences of opinion with the CEO. The Post Office was slow to react to breaches in their duties as a prosecutor because the CEO and EXCO collectively did not acknowledge that the Simon Clark advice or the substance of it revealed a problem with prosecutions, nor did they take them as a coherent picture to the board. The board also has a duty to challenge the small issues before they become big ones. The board knew about the need for disclosures, about the possibility of some miscarriages of justice, and about problems with bugs. These were explicit or implicit in the content of and subsequent board update on the report. The board should have had frank discussion with the CEO about what the board must understand in relation to miscarriages of justice in order to be able to to recognise the problem before it got out of hand. Had they done so, management might have shown that they knew much more about the issues associated with disclosures than was revealed. That's quite the list of issues and problems. Can you help us, the series of issues that you list there in relation to the essentially consequence management as a result of the advice? In the spectrum that I've notionally got in my mind of seriousness, where does this sit?
you will know I didn't have that spectrum in my mind,
No.
but I'm happy to respond to your spectrum. But before I do that, I think a very strong element of that conclusion is that elements of the advice were known. All the advice was known to the General Counsel. Elements of it were known to the board, who knew that they had to review all criminal cases. Elements of it were known by the CEO, who knew that they had to review all criminal cases, and also who quite quickly knew there was a problem with the witness. But as she says, she didn't fully understand what that problem was. So it's not a question that this is the Simon Clarke advice coherently bound up and it was kept from people. Bits of it had come off and were held by various people. And the first point, I think, of our conclusions, taking them as you're wanting us to do as a sum, is that there was nobody apparently thought to draw all those together. All the players had bits, and they were bits which were related to to post offices' prosecutions of sub-postmasters, which was a major issue for MPs, the media, and so on. And as such, we would have expected, that they would have been pulled together and that one would have taken this coherently. So what should have been done with the Simon Clarke advice? It would have been wonderful had it been bundled up and immediately distributed. It wasn't done that. Nonetheless, elements were known, and those elements should have been brought together by the various people and interrogated. That is what I think we are concluding. I'm going to find out from Dr. Steward if she wants to add any more.
I think there is a serious, if you like, kind of dropping of the ball or slipping between the cracks here as well. That this was an opportunity to review Post Office's policy on prosecutions, and the seriousness of not having that conversation, either at the Audit and Risk Committee until later on, and even then with information that was not unambiguously clear, meant that there was a material decision, if you like, which was delayed as a result of the handling of this case.
And so if I've understood both of you correctly, you're saying although the advice or the substance of the advice should unequivocally have been passed to the board, there were nonetheless fragments of it that both the CEO and the board knew about, which was sufficient basis for each of them to have taken the further action that you recommend.
That is exactly the case, and we do see some parallels between that and the previous case that we have looked at, where similarly important fragments were known.
Can we turn to issue 3, please, which is in fact identified on the screen here? Internal and external conflicts of interest. You set out your conclusions here on page 131, which is just over the page. At the foot of the page at 490, in this paragraph and 491. Can you summarise for us 490 and 491 this issue that you're addressing here, internal and external conflicts of interest?
You would like us to summarise?
Yes.
Right back in the Companies Act and in throughout the codes of corporate governance for the UK, the identification of conflicts of interest are always present. It's understood that in governance and in management, conflicts, divergent interests can inevitably emerge. Their existence isn't the problem. The problem is how you address them. And what we identified here is that, and I should say that if the conflicts exist within the executive, then it's the chief executive's ultimate responsibility to identify them and to handle them, although one would expect members of her organisation to represent them to her, but she is ultimately responsible for the structures and for any conflicts that occur there. In the board, if the conflicts exist, it's the chair's responsibility to call them out and to say, well, how are we handling these? And so if someone's got a conflict of interest, they should have been discussed. Now, it seemed to us that the General Counsel, as we've said, had multiple hats. She had the hat of being the General Counsel with her independent advice. She had the hat of being head of legal, which embraced and included the conduct of prosecutions, and she was a member of the executive team. Elements to do with prosecutions which required inquiry meant that, in a way, she was inquiring into aspects for which she is responsible, and one would normally expect that at least to be acknowledged and to consider how that should be handled. With regard to the previous case study that we've looked at, she was also asked to inquire into what had gone wrong with the management for which she had been responsible. So our conclusion is that there were conflicts there. They may not have had any impact. We're not saying they had an impact, but we're saying that they existed. They should have been addressed, and they should have been discussed on how they would be handled.
So to summarise on internal conflicts, you're saying that the second site report, the Clark advice, and the work thereafter highlighted or potentially highlighted the existence of failings on the part of the prosecution function, or risked the revelation of such problems, and that it might be in the interest of the General Counsel that the full extent of such failings did not come to light or minimised.
That could be argued. We're not making conclusions on that whatsoever, but the very fact that the structure was such as you've described and I described means that the conflict was potentially there and should have been addressed.
Can we go over the page to 491, please?
Yeah.
Here you're dealing with external conflicts. And is the summary of it this, that in respect of Cartwright-King, the potential conflict was stark. They were reviewing cases that they had previously had conduct of.
Indeed.
Is that the long and the short
That
of it?
is the long and the short of it.
You pose some questions. What was put in place to ensure that the firm were not overly concerned to make sure their own part in the prosecutions historically was protected? Did the board and the CEO ask these questions about whether Cartwright-King could ever be truly independent? And you say it was a question the board should have addressed with the CEO. Did you see any evidence that those questions were addressed with the CEO?
I think I'm right in saying that Brian Altman did review, or was asked to review, in one of his advices, the independence of Cartwright-King.
That's right.
It is, be absolutely frank, I think that was legally privileged information, so it's quite difficult to tell where that went to and who saw that. So that's the...
But there was reference to the fact that it was understood. I think it was indeed the General Counsel who felt that it would be appropriate, and probably others as well, that they should be somehow assured that this conflict did not in any way influence what they were doing, and the advice was that SIFT was very well conducted.
And you're essentially saying that the board ought to have become involved in probing that?
I believe that that would have been appropriate, given the conflicts that we have described, and given the spotlight which should have been upon the way in which the Post Office was conducting its prosecutions. It would have been appropriate for the board to assure itself that those conflicts were not in evidence.
You turn in underneath these paragraphs to issue 4 in case study 3, communicating risk, and set out your conclusions on page 134 in paragraphs 500 to 503. Is there anything you wish to add to those paragraphs about the about communication in this episode?
I mean, the only thing I would add to sort of sum all this together is that across a number of these case studies, there seems to be a common theme of the communications of shying away from confronting where there has been wrongdoing or fault. So the partial telling of stories, the leaving of half the story, but not the full story.
And I think if you look earlier on, before the conclusions, you'll see a number of examples of that. And this, again, as it says in 502, or as we say in 502, there was opportunities, perhaps, for the non-executives, in our words, leaning in, being curious, challenging the case for future prosecutions and what should be done about past prosecutions within a more holistic risk framework in which we took account of the risks which were not to crystallize until several years later about the way in which Pol was conducting its prosecutions, the way in which it had conducted its prosecutions, and its reliance upon Horizon data.
Thank you. Can we turn to the executive understanding of risk, page 135? And then your conclusion, please, on page 137. You say that the role of the CEO was critical in creating an executive and management focus on risk discussions. The CEO was not able to bring prosecutions risk to the attention of the Post Office executive because, at a minimum, she did not understand it. Without the risks relating to the Simon Clarke advice being clearly framed in the executive, it was impossible for managers to go back to their functions and start building governance around risks. Good governance of risk requires the risk to be fully shared and agreed in ExCo, cascaded into the teams where it is discussed and plans and mitigations are formulated for consideration within the risk framework. So here you're essentially looking down rather than up, is that right?
Exactly, and we're saying at this sort of pivotal point of the executive, if you don't have a coherent understanding of what the risks are, how they are posed for the organisation, then it's extremely difficult for those lower down in the organisation to see what that bigger picture is and then begin to contributing their information, which will be held lower down in the organisation, towards constructing a richer framework.
You turn to issue 6, immediately underneath these paragraphs, which is Post Office culture, and give us your conclusions on page 141 at the bottom. In paragraph 535, and you tell us that it seems to you that Post Office culture, with its underlying taken for granted assumptions, was so strong that the CEO and ExCo did not see any link between persistent underlying flaws in the prosecutorial process and the evidence that the Post Office had not taken the concerns of sub-postmasters seriously. They lived without question within their accepted beliefs. It was as if miscarriages of justice were a mirage, not quite real, and the SIFT review was required because of the disclosure about bugs, not an unsafe witness. Is there anything you wish to add to that?
No, I believe we have laid out earlier on the prevailing views about the robustness of Horizons, the public duty to prosecute to protect public money, the approach to sub-postmasters, and that these gave a set of taken for granted assumptions which meant that information which was readily available, and indeed in the case of the Simon Clarke advice, explicit in a piece of advice, was not taken into, as we've said, a holistic view of what was going on in the business. Do you want to add?
No, that's very clear.
Over the page to 537, you say that it seems odd to you that the chief executive and her ExCo did not seriously challenge the assumption that Post Office had historically been right to pursue prosecutions on the basis of Horizon evidence, even though both general counsels in the period 2013 to 14 held personal views that Post Office should not be conducting private prosecutions, and at least some members of the team were aware that Post Office had breached its duties from the Simon Clarke advice. Can you explain or expand upon the oddity which you discovered, or the oddity about which you speak about?
Well, that trying to put ourselves into the position, we find it very, very difficult to understand that with all these pieces of information, it didn't lead someone to say, should we immediately agree to stop private prosecutions, even though, as we've said, both general counsels have said that in their view, they don't feel that this is something that should continue. The fact that they didn't continue because they were still looking for another witness, the fact that they were ceased or paused is neither here nor there with regard to should we be doing this in this manner. And we find it odd that that assumption wasn't challenged. Do you want to add?
No.
Thank you. Can we turn to your overall conclusions on case study 3? There at the foot of page 143. And you tell us that case study 3 provides your description, analysis and conclusions on 6 issues, which are important in evaluating the way in which the Post Office executive handled the clerk advice. It should have been escalated to the board. However, if it is found that there was a failure to do so, in our view, it's not a failure that can simply be laid on the General Counsel. It was a responsibility of the CEO and the executive, not just the General Counsel, to have reviewed the conclusions of the clerk advice and made recommendations to the board, and ultimately a responsibility of the Chief Executive to ensure there's a focus on all top-level risks in the business, so that all members of the executive team feel part of a shared endeavour in which they will identify, communicate and mitigate risks in their areas and escalate them with urgency when needed. Is there anything you wish to add to that overall conclusion on case study 3?
No, thank you.
Thank you. That's the end of the case studies. Can we go back briefly then to look at the 9 themes that you identified in the light of them? Page 13 of the report. I should have started at page 11, actually. And I'm not going to adduce each of these in evidence in the same way. The report speaks for itself, and others can ask you questions if necessary about them, but just work out what's going on in the report so we can all understand it. This is the first of the 9 themes, board-level governance. And if we go on that page, you identify what the issue is, or the importance of the issue is. Here it's about strategy and risk. And then over the page, in paragraphs 23 and right through to 30, you identify evidence relevant to that issue. And then at the foot of page 13, you set out your conclusions. And essentially is what you're doing from paragraph 31 onwards, identify material from each of the 3 case studies that's relevant to the theme that you have identified.
Indeed, that's
And
the
so
case.
to take this one as an example, you say in 31, the second site case, so that's our second case study, illustrates the board did not see the major problems in prosecutions, investigations and culture that have been included in the report. All 3 cases, second site, Simon Clark and Wolstenholme, illustrate that the executive did not systematically identify key risks in prosecutions or in their approach to sub-postmasters, or propose how they should be mitigated. They didn't challenge the executive approach, even though they had information before them that suggested serious risks. In 2013, the board didn't take the opportunity to open a window to see the bigger picture. In our view, events and discussions during July 2013 reinforced rather than challenged the prevailing view of the nature of the problems. The approach that all things to do with Horizon were operational and therefore an executive responsibility regardless of indications of serious risk, particularly in prosecution policies and practices, was a governance failure. And you do that in relation to each of the 9 themes, essentially. Is that right? The structure
correct.
that I've outlined.
Yeah.
So in relation to this one, for example, and perhaps building on what you say, would you agree that the way in which the Post Office exercised its powers of private prosecution as a routine part of the business, for example, the creation of an investigations department, a prosecutorial department, was a significant risk across the period that you've examined?
When you say the creation, that of course goes back hundreds of years or
Yes.
decades.
Maintenance of.
Thank you. So the maintenance, the continuation of
Yes.
that. And the question is, do we see that as a serious risk?
Yes.
Yes.
Yes, if unless there is very, very good governance in place for prosecutions.
Oh, sorry. That's certainly
It is-
the case.
It is a serious risk, and there needs to be proportionate levels of governance in order to ensure that the risk of prosecutions is...
Let's look at it another way round, rather than through the prism of whether there was a risk or not. Would you have expected the executive team and the Post Office Board to have had a clear understanding that the Post Office routinely conducted its own prosecutions of sub-postmasters on a very significant scale?
We would have had that expectation that they would have understood that.
That they were engaged in that activity?
Yeah, that they understood that the Post Office was engaged in that activity.
And is that because the exercise of a private prosecution function is an exceptional activity on the part of a company?
Well, first of all, it's because all business which is undertaken in the name of the company, the executive who is running the company has a responsibility to understand what they're doing, and the board has a responsibility to have oversight of what the executive is doing in running the business. So it's an element of the business. It should be duly understood and managed by the executive. In this particular case, there was a lot of external evidence that there were problems in this area, and so we would have expected them to be particularly focused upon it.
And I'm focusing on the area in between those two things. A board should be aware of all of the activities that the company undertakes. I think was the first part of your answer. And then the last part of the answer was, but here there was evidence of problems with the discharge of this function.
Yeah.
And I'm asking the part in the about the part in the middle, perhaps. Was the nature of the activity being undertaken one which you would reasonably expect a board to have paid particular attention to, irrespective of whether it was problematic in fact, i.e. bringing employees or quasi-employees before the criminal courts?
I'm going to slightly step back and say, still addressing the first point, which you say is between the first and the third point. As a board member, when you join a board of an organisation, it is important that you understand what that organisation does, what its purpose is, and what its various activities are and how those activities are organised. So I would expect a board member to have that general understanding. If I then was in this board and I understood that part of those activities were to bring exceptionally and perhaps anachronistically, as I believe Brian Altman says, prosecutions under the private route, I would have expected them to be particularly interested in that, had they known it, yes. Is that?
What about, if we add this into the equation, that the Post Office was in perhaps an unusual position because it was the alleged victim of any crime, it was the investigator of an alleged crime, it was the decision maker as to whether or not to bring proceedings or not about the alleged crime. It was the generator of the evidence about the alleged crime. It was the prosecutor for the alleged crime, and it was the potential beneficiary of a proceeds of crime order for the payment of money back to the post office. Would that series of roles have added to the risk register?
I think it would have both added to the risk register for exactly the reasons that you're alluding to, and it would also have, because of that, it would have had a special interest, if I had been on the board and understood that, it would have had a special interest to me to understand what governance and safeguards were being employed in that aspect of the business.
Would you have wanted to know, for example, the extent to which there was any external oversight of those functions by, for example, a regulator?
I imagine that that would be a question that I would have wished to ask.
Thank you. Can we go back to your themes? If we can turn to the second theme, please. Which begins on page 14. Halfway down, that's it, we've got it at the top there, accountability and clarity in board roles, with special reference to the identification and escalation of serious problems. I think you set your conclusions out about this at the foot of page 17. And in fact, it's just a heading on page 17. It's the substance begins on page 18. And from paragraph 49 right through to 56, you address the issue of accountability and clarity in board roles with special reference to the identification and escalation of serious problems. Without going through each of those 8 or 9 paragraphs, can you help us overall with what you found, what your conclusions were?
I think at the beginning of this report, we talk about the fact that board governance and executive management are separate and yet entirely interdependent activities to ensure appropriate governance of an organisation. The executive have a responsibility to bring information to the board. The board have a responsibility to look into the organisation and see what they think they should know in addition to that which the executive is bringing. And accepting that the executive does the operational running of the business, the board does the oversight and the determination of strategy and the other things that we've managed. So accepting that there are differences, nonetheless, the two elements need to work together. And we have found, I believe, that these two elements didn't work effectively together in order to bring relevant information into the board. And it's the responsibility of both of those sides. That's the first thing. The second thing concerns the separation between operational, which is the executive's role, and oversight, which is the board role. And I believe, is it here that we say that that distinction is good and it prevents the board overly interfering with what's going on in the business, because that's the executive job. But it does depend upon the board believing that performance is within accepted bounds of acceptable and that they've got a good and strong executive team. If they've got doubts about either of those matters, then they need to inquire further and deeper into what's going on. And we don't feel that, as is asserted in the evidence, where people have said, well, it was an operational matter, so we weren't concerned with that from the board. We don't think that that's a robust enough defence for what happens, because it was an operational matter in which there were clearly problems. In prosecutions, there were problems, as was being evidenced by as we've said, all the external evidence. And with regard to Horizon, there were also evidence that there were indeed bugs, defects and anomalies which could call into question the robustness of the system.
Can we turn to the third theme, please? Page 20. The heading above paragraph 57, effective communications in and around the board. You set out your conclusions on page 22 at paragraph 66. You say the identification of or change in a major risk should quickly lead to a communication to the board about the risk, ideally accompanied by proposals for board discussion and decision about how it will be tackled, including an outline programme of work which would enable ongoing board oversight. We've seen no evidence that this was done in any of the three cases, as information was surfacing about major risks arising from Post Office past and current investigations and prosecutions. The execs did not do this either before or at the board meeting of 16th of July, on receipt of the Clark advice in 2013, or in 2004, when Mrs. Wolstenholme brought a counterclaim against the Post Office for £180,000. And then 68, relevant information in each of our three cases was neither offered nor elicited in ways which in our view would have represented effective communication between the executives and the board.
It goes back to the point I made earlier, which is about the requirement to offer and the requirement to elicit. And we find no evidence of that being thoroughly and effectively done with regard to the matters before the inquiry.
Can we turn, please, to theme 4? The heading is set out there above paragraph 69, expected experience, development and competence of the board and its members. And you set out your conclusions on page 26, a series of conclusions right up until paragraph 90 on page 27. You address a range of things, experience of individual board members, composition of the board, role that the NEDs played, the NEDs' understanding of what their role was. And you say in paragraph 90 on page 27, you hadn't seen evidence that sufficient thought was given to the development and operation of a unitary board in circumstances in which Post Office ownership changed several times, and problems with Horizon prosecutions and culture were surfacing in many places, but not in the board. Can you expand upon or explain your conclusions here, please?
In the transcripts and witness statements that we have reviewed, non-executives joining the board, more or less to a man and woman, I think, said that they were not given explicit induction into the Post Office's approach to prosecutions or to any problems in relation to Horizon. That's the first point. The second point is that given the changes in ownership over this period, the issue of accountability on who had the locus for doing what needed to be very clearly explained, going back to very much where we began this morning, in understanding who was accountable to whom for what in those different structures. And it's not clear to us that that was really thought through. The third element is that the appointment of non-executives was mainly, it seems to us, driven by the need, as was seen at the time, to introduce people with commercial experience of how to run a successful commercial business which would be mindful of cutting costs, of making profit, of running it in a way in which people understood private companies run. The very fact that it was a commercial enterprise, and yet with a very strong public service requirement, indeed in the entrustment, how that was to be played out within the board and where the attention of the non-executives was to go in relation to all those aspects doesn't seem to have been confronted in induction or indeed in the way in which particularly the non-executives saw their role, which they saw as mainly offering commercial expertise and advice, and indeed their backgrounds were very much from that background. Do you want to add?
Can I ask you about the role of the company secretary in this regard? Can we just go back to your first report, please? And page 29. It'll come up. At the foot of the page, paragraph 2.2.33, you tell us that the company secretary is an officer who's appointed by the directors to advise the board on all governance matters and codes. They'll normally seek to ensure compliance with companies' legal obligations. Accountability is to the board and to the chair to ensure that all appropriate governance measures are brought to the board's attention. As regards functioning of the board, they're technically independent of the CEO and accountable to the chair. As an executive colleague and in a sense subordinate to the CEO, they need a very good working relationship with the CEO, who's likely to be very influential in their relationship. And then you set out a company secretary's accountabilities over the remaining 5 paragraphs. Is the overall responsibility for the handling of a company's legal obligations and regulatory compliance normally dealt with by the company secretary?
At an administrative level, that is certainly the case. That is keeping all the records, maintaining, as is said there. You'll note that it says working with the chair to ensure that all board members are aware of their duties and powers, and working with the chair on the board agendas. So the relationship, the company secretary cannot be said to be solely and singly responsible for all that compliance, that is ensuring the compliance. But if he or she were to notice that the board was non-compliant, then she would have a duty to identify that.
Whereas between a company secretary and, if the company has one, a general counsel, does overall responsibility for regulatory compliance sit?
Well, the general counsel, as I think I said this morning, isn't formally identified in the codes of governance as we've identified here. And
sorry, just stopping you there. It's right, is it, that there isn't any legal requirement for a company such as the Post Office, whether under the Companies Act or the code, to have a general counsel?
There is no requirement.
Yes, sorry, I interrupted you. I
Yes.
probably interrupted your train of thought.
So as there isn't that requirement, you can't say, well, what's the split between the company secretary and the general counsel?
If a company does have one,
Yes.
as this one did,
Yes.
Where does responsibility for regulatory compliance reside, as between
I
those two
don't-
individuals?
I think that the role of the company secretary can be kept separately from the role of the general counsel. I think the fact you may have a general counsel doesn't alter the requirements of the company secretary. Unless there was some specific agreement about the way in which these relationships and duties were to be performed, which would be very formally laid down and may therefore lead to some change. But I don't think that an occasional, do we have a general counsel or not, can impact on the duties of the company secretary. That's my view, although, yes, that's my view.
In terms of the role of the General Counsel, is the General Counsel normally accountable to the board or to the CEO?
I think, again, you might find particular arrangements. It's normally the case that the General Counsel, for what one might say sort of pay and rations, administratively, is going to work to the Chief Executive, especially if the General Counsel also has other responsibilities which are to do with their functional responsibilities for, in the case of the Post Office, for the legal teams and for other elements. Indeed, as you'll be aware, the General Counsel, until the day after the board meeting of the 16th of July, also had responsibility for HR, which would mean that she was directly working to the Chief Executive. Having said all that, the normal expectation is that the General Counsel would have at least an informal dotted line to the chair and to the board, so that if he or she felt that they had a matter which was germane to their legal position, which the Chief Executive either didn't understand or wasn't interested in, that they would be able to take that indeed to the board and to the chair. So how these relationships actually work out is going to depend upon the way in which the organisation works. What one can't do, and although I'm not an expert on it, one can't take away from the General Counsel's requirements as a qualified lawyer to meet certain professional obligations.
Do you know, in fact, whether there is a requirement for General Counsel to hold a practicing certificate or even for a General Counsel to be a qualified lawyer?
I personally I'm not aware of that. It's not an area of my expertise.
Thank you. I won't ask you the questions that follow from that. Can we go back to theme 5, please, in report 2, which is page 29 in report 2. Your conclusions here are addressing theme 5, which is whether there was a board culture supportive of effective discussion and decision making. You say that you've seen how Post Office's governance structures were still developing in 2013. The executives were inexperienced in working with NEDs and running an independent company. Earlier in 2004, the Post Office was still a subsidiary of Royal Mail Group and had only 1 year experience of working with a non-executive chair. The first NED to join the chair was only appointed in that year. The NEDs appointed at different times were consistent in their views. Their main role was to instill commercial disciplines to improve performance. Your analysis of those 2 cases in 2013 illustrates situations where the culture and conduct of the board did not encourage the board in effective prioritisation, discussion and decision making about what Post Office should do with regard to past prosecutions and with future prosecutions policy and practice. This is under the heading of, I think, culture. Why is this relating to culture or board culture?
I think it goes back to the earlier questions of what were the things that were preoccupying the board and how did the board also behave. So culturally, we have seen these dominance ideas of horizons robust, prosecutions are in the public interest. Sub-postmasters occasionally are subject, are guilty of wrongdoing, and we must defend our public position. And that set a context in which one approached, or they approached, past prosecutions and future prosecutions policy and practice. And even though there were indications that this was an area which needed their strong attention, they didn't focus upon it. We've also seen how in the particular board meeting of the 16th of July, issues that were available to the board were clouded over by the non-executive irritation with the way in which the second site work had been handled, and they were not then brought into a focused discussion by the chair. That's why we have identified that in terms of conduct and culture.
Thank you. You address theme 6, policy and practice for handling conflicts of interest from paragraph 98 onwards, and set out your conclusions at paragraph 108 at the foot of page 31. I think there's nothing additional in that paragraph beyond which you've mentioned already, is that right?
I think, yes.
Thank you. Theme 7 starts over the page, and this is moving from board to executive, is that right?
Yes.
The last three themes, 7, 8 and 9, are all to do with the executive. The first of which is structures and relationships, and you set out your conclusions on this issue at paragraph 116 at the foot of page 33. You say the case studies featured in the report suggest a number of obstacles to effective executive team working and collective accountability. Over the page, thank you. It's the CEO's responsibility to make appointments to senior exec positions of individuals who have the experience and skills to enable the CEO to delegate responsibility. The CEO cannot absolve themselves from responsibility on the basis they've delegated, or they are not an expert in any field. They have a responsibility to create relationships with their executive colleagues so that whilst not an expert in every field, they can rely on and invite their colleagues to keep them informed of major matters. That's especially important if the colleague is not a board member nor is regularly in attendance at the board. Are you referring there to the General Counsel?
I am.
You say, if we scroll down please, at 120, that you found very little evidence that the group of senior executives in Post Office felt they were working as a team in any of the 3 cases featured in the report. So that's across the 3 case studies, is that right?
Yes.
And then over the page, please. At 123, you say the Second Sight and Simon Clark cases suggest a strained relationship between the CEO and the General Counsel, as well as between the Chair and the General Counsel. Problems and dysfunctions in the way the CEO operated with some of their senior executive colleagues, and the apparent lack of an effective executive team taking collective responsibility, which were revealed in those 2 cases, are a reflection of the compound impact of strained relationships, structural silos, a CEO who did not see her role as needing to be closely in touch with all areas of the business, and the fact that the GC was not a member of the board. Again, that's quite the list. How, on my imaginary spectrum, and you and perhaps even me don't know the beginning and the end of it, but where does the list of issues that you have identified there sit in the spectrum of seriousness? If you're more content to simply say this was or was not a failure in governance, then please do say so.
Well, as we've explained, governance isn't a isn't a cup of water which is either broken or not. I mean, it is a cup of water which may be beautifully overfilling with beautiful water, or it may lose bits along the way. And what we've identified there is the problems that can arise within an executive team, which we think we have illustrated in relation to the case studies. And of course, the case studies are only illustrations. As we've said, we've selected them, but there may be other evidence of which we're not available, we did not review. But it seems to us that compound effect, there were strained relationships, there were structural silos asserted. There was a CEO who said sometimes that she was not an expert in that, or that she was not aware of certain matters, and yet she could have been had she asked the executives responsible for them to contribute in a stronger way to a collective executive understanding. But it's especially difficult if any member is not a member of the board, then it's the CEO's special responsibility to be able to understand sufficient about that area to be able to represent it to the board. So a combination of these effects meant that the effective role of executive management and organisation, that one part of the governance which interrelates with the board, worked suboptimally.
Thank you. Can we turn to theme 8, which is identified in the heading that's on the page there, performance and capability, and turn to your conclusions on page 36, paragraphs 128 and 129. You say it's the role of the board to challenge and support the executive unless there is consensus amongst the NEDs, that there are sufficient concerns about executive performance to conclude there should be a change at the top. Boards and shareholders can find themselves at a pivot point between continued support and time to plan for executive exit. One cannot, in our view, sustain a long period of half support or half exit. Having got to such a point, it would be usual to follow through on the expressed concerns with a view to clearly demonstrated improvement, or to put in place succession plans about an exit. What are you referring to, or to whom are you referring here?
I don't know if it is in this evidence. I'm afraid I can't recall where we talk about it. UKGI had identified that there were concerns both by the board and by UKGI about the performance of the chief executive. They were raised at a committee in UKGI. They went for a review. The review concluded that there were problems both with regard to the fulfillment of the strategy and with regard to the capacity to form effective relationships within the executive team, especially if they were with people whom the chief executive found to be challenging. I think I've got that right. We also heard in testimony, in oral evidence from the non-executive directors, that there had been some concerns about, there were certainly concerns about the General Counsel, but there were also concerns about the Chief Executive. And so concerns raised, they took them to a particular point. In fact, UKGI undertook an exercise with an external headhunter to see what would be in scope for if the chief executive were to be replaced. In fact, it was decided that she shouldn't be replaced. It seems to us largely on the basis of the fact that she wasn't doing that badly, and also that it was difficult to find a replacement for the given salaries. To us, that how you leave that, and perhaps we haven't seen all the evidence, but how you leave that is unsatisfactory from a board perspective, because you're neither concluding that everything is fine, nor are you concluding that everything is awful. And that creates tensions, which we haven't looked at because this is post-2013, but it creates an unsteadiness in the board. Do you want to add?
And so if we just scroll up to paragraph 127, you were rightly remembering the evidence of January 2014, where UKGI or SHIEX was considering the suitability of Paula Venables to remain as CEO. And I think you had drawn to your attention some other material that exists,
Yes.
showing continued consideration of that issue well into 2014, including discussions with the Minister's office, Joe Swinson's private office, including a speaking note about what might be said to the Minister about Paula Venables, including email exchanges about what the Minister might be told about SHIEX's view of Paula Venables, and the tender document that you just mentioned for essentially recruitment consultants to go out and recruit a new CEO. Does any of that alter the substance of what you say in paragraphs 128 and 129?
We were left with the view, even having reviewed that, that it still seemed to be half support. Perhaps it wasn't half exit because the half exit had not proved not to be a viable avenue in their view. But it wasn't a wholesome and wholehearted endorsement.
Can we turn to theme 9, please? It's identified in the heading there, organisational culture, and you set out your conclusions on page 39 in relation to this, through to page 41. At 138, you say that Horizon represented a huge investment and change in operations. By its scale and nature, it inevitably posed risks. If only from popular public discourse about other large-scale system changes in public services, people involved in the commissioning and rollout of Horizon in its various guises would have been likely to countenance that serious problems may arise during its commissioning and operation. By any normal analysis of major system change, sub-postmasters were very important end users. They were in the front line of customer public service. It would have been normal, over the page, to listen, learn from and follow up on sub-postmasters' views and experiences. In paragraph 140, you say it seems to you that the culture of Post Office did not encourage listening or learning from sub-postmasters. The nature of their contract with the Post Office and their experience of Post Office investigation and audit teams seems to be part of the company ethos in which sub-postmasters were taken for granted and seen as insignificant. And then paragraph 141, the report was an opportunity for the board to see it was important to hear and listen to sub-postmaster experiences of working both with Post Office and with Horizon, and their voices remain unheard. And then if we go on to paragraph 144, which is just at the foot of the previous page, the board's handling of the report, it is striking that no member of the executive of the board asked out loud what is the right thing to do about the sub-postmasters who are suffering so much and are protesting their innocence. So deep were the assumptions embedded in the culture of the organisation, so corrosive was the company ethos that the board did not call the executive to account. To face up to the Post Office's role in perpetuating miscarriages of justice, which were increasingly evident to others. Failure to uncover and correct the dark spots in the culture is a failure of management and governance. I think they're probably the strongest words that you use in the course of this report. Would I be right?
Yes. Would you like me to expand?
Well, if you can explain, yes.
Yes. And they're strong because the issue of the culture of the Post Office, with its perceptions, as we've said several times, about what Horizon was, what sub-postmaster's role and approach was, and what the public duty of the post office was, created such a strong sense of what was right in the organisation that they found it impossible, apparently, to really hear in 2013 that people were talking about and had bits of evidence about miscarriages of justice, wrongful prosecutions, and an arrogant and a defensive approach. It was as if they somehow couldn't be heard. And so we conclude on that note because we do think that it actually underlies a lot of the matters that we've been discussing today. Perhaps before I ask Dr. Steward to also comment, I'd say that at the beginning of these conclusions, we say even if you don't take account of these moral cultural points that we're making, actually having a major systems development, putting in new systems, one of the basic points that we understand is that you find out from the end users what's actually happening. Because in these complex systems, the end user, the facing to the public, is the place where the system is experienced absolutely at the front line. So even if you didn't take the moral and ethical matters that we're addressing at the end, you would say from an instrumental management effectiveness approach, you'd want to listen and learn from what was going on at the front line. And in 2013, and indeed in 2004, I think that should have been understood. So there was an instrumental reason as well as our conclusion on the moral reason. But on the cultural matter...
I think just the sort of topping and tailing that is that the board should ask questions about the culture. They can't know the culture in the way that the executive can know it. They can't shape the culture in exactly and precisely the way that the executive and the management team can. But the board and the non-executives, particularly with everything that's going on around it, should be asking questions about what is the ethos of this organisation, what is the culture of this organisation. And if you look across the 3 case studies, there are, if you like, examples in all of them where there is, we use the word insignificant, or an indifference to the experiences of sub-postmasters. And that appears to be part of the culture.
Thank you. Those are the questions that I asked. Thank you very much for answering all of them. Can we take a break now, sir, until tomorrow? There are questions from core participants, and it will give them an opportunity to formulate them. I'd ask, however, we start at 9:30 to ensure that we finish by 12:30.
And can you just give me an idea of how many sets of questioners there are?
There are 5 sets of questioners. The Hodge, Jones and Allen core participants, the Howe & Co core participants, the Hudgels core participants, the National Federation of Sub-Postmasters, and the representatives of Paula Venables.
And you will agree with council suitable time estimates for each of them. And can I say now, since it's something that concerns me, I would strongly take the view, I think, that questions from Miss Venables' advocate should come last, because I suspect, though I don't know, that questions from most other people will be with a view to making things worse for the post office, whereas questions from Miss Venables may be to opposite effect. And I think she should know the full scale of what's being said before she asks her questions. I said that's a strong view. I'm always open to persuasion, but that's what I currently think.
Thank you very much, sir.
Now then, how do I direct a witness about not talking to anybody when there are 2 of them?
I hadn't addressed that.
I think you can talk to each other.
Thank you very much.
See you tomorrow morning.